Hello, my dear friends. I'm Dr. Waseem I Khan, Assistant Professor, Shri Shivaji Law College, Parbhani, Maharashtra, India. In today's lecture, we will discuss a third part of tort of strict liability, that is, defenses or exceptions available for the tort of strict liability. So, let's start the topic. Strict liability and its exceptions. So in the previous two lectures we have discussed the case of Reliant versus Fletcher, and in the second lecture we have discussed the essentials of strict liability. There are three essentials of strict liability. If the plaintiff wants to get a compensation under the principle of strict liability, he must prove that whatever the things brought by the defendant, that is a dangerous one, and that dangerous thing which was accumulated by the defendant, it escape outside his premises, and the accumulation of dangerous thing amounts to a non-natural use of land. If plaintiff proves these three essential, he will get compensation. But at the same time, defendant is having a certain defenses by taking which defendant can avoid his liability, and we will discuss in this lecture those exceptions. So this introduction part we will skip because we have already discussed in the previous lecture. If you have not watched those lecture, you can watch that particular lecture from my YouTube channel. So we will directly move towards the exception to strict liability. The first exception to the strict liability is plaintiff's own default. So if the plaintiff suffers damage by his own intrusion into the defendant's property, we have discussed that when defendant will be liable under the principle of strict liability if he brought a dangerous thing on his land, and if that dangerous thing escape outside his premises, then only he will be liable under the principle of strict liability. But suppose the dangerous thing remains on the land of the defendant, and if someone else enter into the land of defendant and he got injured due to that dangerous thing, then under such a circumstances, if plaintiff filed a suit against the defendant, defendant will be entitled to take the defense, that is plaintiff's own default, because dangerous thing didn't escape outside his premises, but the plaintiff himself entered into the premises of the defendant. That's why it is the fault of the plaintiff himself, and defense of plaintiff's own default will be available for the defendant. Ponting versus no case, that is a particular case. The plaintiff horse intrude into defendant premises. In this case, the plaintiff horse entered into the premises of the defendant and died due to nibbling of leaf of poisonous tree, and the defendant grows a poisonous tree in his premises. Plaintiff horse entered into the premises of the defendant and died due to the nibbling of poisonous tree's leaf, and the plaintiff consequently filed a suit against the defendant. Due to your act, my horse died. But in this case, the defendant took the defense of plaintiff's own default. In this case, the poisonous tree is no doubt a dangerous thing, but it was not escape outside the premises of the defendant, but the plaintiff's horse entered into the premises of the defendant and died. And that's why court says that the defendant is not liable, because the plaintiff's own default is a defense available for the defendant. Second defense for the strict liability is act of God. When the act of God defense will be available for any person, if there is a use of natural force, and if the occurrence must be extraordinary, whatever it may be the natural force, if that natural force is extraordinary, then defense of act of God will be available. So there is a one case in which the defendant took the defense of act of God, Nicholas versus Marshland. In this case, defendant constructed an artificial lake by damming of the water from hills. So one night, due to the heavy rainfall, the water overflows from that reservoir, that lake, and it washed out the bridges which was constructed by the plaintiff. Plaintiff sustained a loss, and plaintiff filed a suit against the defendant, and in this case, defendant took the defense of act of God. So whatever the water collected by the defendant by damming of the water, it amounts to a dangerous thing, but it also escapes outside the premises of the defendant, but the court says that escape was due to the act of God, and that's why act of God is a defense available for the defendant. So by taking the defense of act of God, the defendant can avoid his liability. Next defense is consent of the plaintiff, where the plaintiff has consented to the accumulation of the dangerous thing on the defendant's land. Suppose if the plaintiff himself consented to the accumulation of dangerous thing, and after giving a consent, if he sustained any kind of injury due to the dangerous thing, he can't file a suit against the defendant. And if he filed a suit against the defendant, defendant will be entitled to take the defense of consent of the plaintiff, because plaintiff himself consented to the accumulation of dangerous thing. That's why the defendant will be able to take the defense of consent. Fourth exception or defense for the strict liability is act of third party. If a harm caused due to the act of a stranger who is neither the defendant's servant nor the defendant has any control over him. Suppose if a plaintiff sustained an injury due to the act of some stranger who is not the servant of defendant, who is not the servant of the defendant, as well as the defendant is having no control over the activity of that particular third person. So under such circumstances, defendant can avoid his liability by taking the defense of act of third party. He can say that the act done by the third party, I was having no control over the activity of that person. So there is a case, Box versus Jug. In this particular case, water overflows from the defendant reservoir due to blocking of drain by stranger. So the water overflows from the defendant's reservoir, and the reason of overflowing of water was blocking of drain by stranger. The stranger blocked the drain of that reservoir, and that was the reason of overflow of water, and the plaintiff sustained an injury. Plaintiff filed a suit against the defendant that due to the overflow of water from your reservoir, I sustained a loss. But in this case, defendant took the defense of act of third party. The defendant said that the stranger has blocked those drain, and that's why water overflows. It is not my fault. So act of third party is also a defense available for the strict liability. Next one is things naturally on land. The rule applies to dangerous things artificially brought or collected on the land by the occupier. When person will be liable under the principle of strict liability, if a person brought a dangerous thing on his premises, if the things grows naturally on the land of the defendant, he will not be liable under the principle of strict liability. Suppose if I brought a dangerous thing, I may be liable under the principle of strict liability, but the things grows or got collected naturally. Dangerous thing got collected naturally, dangerous thing grows naturally on my premises, I will not be liable for the principle of strict liability, and I will be entitled to take the defense things naturally on the land, not the things which grow or get collected on land naturally. If the things collected or got grows naturally, I will not be liable for the principle of strict liability. A person is not liable for escape of thistle seeds. Suppose if the plants grows naturally on the land, if that plant is poisonous and someone else got injured due to that particular plant, I will not be liable for that, because I have not brought a dangerous thing on my premises, but it grows naturally, and in that particular scenario I will be entitled to take the defense of things naturally on the land. Last defense for the strict liability is statutory authority. If statute is empowered to collect or accumulate the dangerous thing, suppose if the statute has given a power to someone to brought a dangerous thing, then he will be entitled to take the defense of statutory authority, even if it cause any kind of damage to any person. Suppose if a statute has given me a power to collect the dangerous thing, and if due to the existence of dangerous thing, if any person sustain any injury, I will not be liable for that, because I have I have brought that dangerous thing because statute has given me a power. So under such circumstances, statutory authority will be a defense available for the defendant. Green versus Chelsea Waterworks. In this case, the defendant were authorized by statute to store water for the purpose of supply to the city. So in this case, the defendant was authorized to collect the large amount of water, and the very purpose of collection of large amount of water is to supply to the city, water supply to the city. And the court says that it is a statutory authority. The statute has given a power to the defendant to collect a large quantity of water. That's why the defendant is not liable even if that water escape, because statute has given him a power. So under such circumstances, defendant will be entitled to take the defense of statutory authority. So these are the 6 defense for strict liability, by taking which the defendant can avoid his liability. I hope you understand this topic. If you understand this topic, please subscribe my channel, hit the notification button, hit the like button, and share this video with your friends. Thank you very much.